on today's Story Beat.
I think the biggest thing you think about is, do I have a compelling story to tell the jury? Do I have a compelling case? Forget about the law. Just like, in terms of what this person did to that person or this company did to that person, whatever it is. Do I have something that I can explain to the jury in very simple and emotional and compelling terms? Or is this a case where to really tell what happened, you've got to dive into a ton of details and you're going to risk losing their attention, and they're going to think because you have to go into so much detail, you must be hiding something and you're really a liar or whatever. What is the core, simple case theme? And is it compelling? And frankly, of course, is it true? In other words, do the facts support it? If you try and sell the jury on something that's not true and your adversary is awake, you're going to get killed.
This is StoryBeat with Steve Cuden, a podcast for the creative mind. StoryBeat explores how masters of creativity develop and produce brilliant works that people everywhere love and admire. So join us as we discover how talented creators find success in the worlds of imagination and entertainment. Here now is your host, Steve Cuden.
Thanks for joining us on StoryBeat. We're coming to you from the Steel City, Pittsburgh, Pennsylvania. My guest today, Robert M. Bobby Schwartz, is a partner in Quinn Emanuel's Los Angeles office and co-chair of the media and entertainment industry practice. Over the last 30 years, Bobby has become a nationally recognized leader in large stakes and often precedent-setting cases, particularly in the entertainment and media fields. He's represented every major motion picture studio and broadcast network, as well as film production companies, pay TV services, video game developers, record companies, recording artists, producers, writers, directors, and actors. Bobby has had extensive experience and success in copyright, trademark, unfair competition, royalties and participations, First Amendment, defamation, employment, and complex business disputes. He's handled more than 100 class action cases around the country. He's also handled substantial disputes for companies well outside the media industry. So for all those reasons and many more, I am deeply honored to welcome the media and entertainment legal powerhouse, better known as Bobby Schwartz, to StoryBeat today. Bobby, welcome to the show.
Thank you very much. Great to be here. Great to see you.
Oh, it's a great privilege to have you on the show. All right. So at what point in your life did you start thinking about the law? When did you want to become a lawyer? Were you a kid or was it later in life?
Probably pretty early on. I took a liking to debate in high school, and it just seemed like a natural extension of doing that. So when I got out of high school and started college, I thought I'm probably going to law school.
So you were into it early on. And were you someone who, when you were in grade school, high school, and so on, that you liked to get into verbal arguments with people?
I liked public speaking. I don't know if I liked getting into verbal arguments. I think I was a bit of a class clown and enjoyed being entertaining in those awkward moments. And not that my parents were happy about that, but I enjoyed it.
And you grew up in LA, yes?
I did.
So
yes.
You were around entertainment industry people early on.
Absolutely. A lot of my friends' parents in one form or another were writers, directors, actors. My father was a motion picture producer.
Oh,
so
yeah?
It got into the groundwater from which we all drank.
So you then, it was a natural transition for you to think about the law and applying it to the entertainment industry. This was not a big stretch for you.
Well, the funny thing is, when I was in law school, first of all, I had no aspirations to practice law. I thought it was really just a great background for whatever it was I was going to do. I thought a lot about the entertainment industry, and some of my friends were trying to encourage me to go into film production with them. And my father said, that's not a great use of your talents. I want you to think about something else. For a while, I actually wanted to just be a ski bum or work as a ski area developer or something, whatever. But eventually I found my way into entertainment disputes, and it seemed just a really great fit.
Well, there are, as you well know, a fairly significant number of folks who have gone through law school, gotten their degree, and then wound up in some form of business in Los Angeles, in Hollywood, that they use their lawyerly understanding to do contracts and make deals and so on, but they're not practicing law per se.
Yeah, that's what I thought I would originally do. And even when I started practicing law, my goal was to get a job at the best firm in town I could get a job at. You develop my skills for a year or two as a deal lawyer, and then go out into the business world. And
Mm-hmm.
at that point, likely the entertainment industry.
Well,
And then just by happenstance, I parked myself for a few months within the disputes part of the firm. It was heavily focused on entertainment industry disputes. And I felt all of a sudden like I was back in high school debate, except I was getting paid for it. And it was so much fun. I just never looked back.
so in other words, it was, but it was a natural transition in LA to be dealing with entertainment industry people. And you already knew a bunch of them. So you were familiar and comfortable with that world.
Absolutely. And it really helped as a young lawyer to understand the vernacular and the life cycle of a television series or a theatrical motion picture, and to stay informed and to go to meetings at the studios we represented and be able to talk to the clients in a way that they felt they were being heard and understood. It definitely gave me an advantage.
My understanding of the business, and please correct me if I'm wrong, that a pretty significant amount of the deal making is the deal points, but the deals themselves are pretty standard throughout, that there is sort of one way to look at, there's two sides, you're going to make a contract between two groups, and that I would think for you, since you found that exciting in the more argumentative part of the business, that is to say litigating, you probably would have been bored having just done contracts and nothing else.
Interesting that you say that, because that was my initial reaction when I was doing entertainment transactional work. We were representing a bank. It was loaning money to some producers who were making a movie, and they were doing a negative pickup deal with, I think, Orion or one of the other companies at the time. And my job was just to take the last set of deal documents for the last bank loan and negative pickup deal and change the title, change the deal, the loan amount, whatever. I was basically just like a word processor.
Mm-hmm.
And I said, well, this is not for me. What I didn't realize was, maybe I reached a rash decision too quickly, is as you move up in the food chain or on the totem pole, the things you think about, the advice you give, and your involvement is much earlier in the process. It's much more useful to the process, and it's far more interesting. So, but I very quickly said, I'm not doing this.
All right, so not everyone has the stomach to be a litigator, to stand up in front of a judge and jury and argue a case. It's sort of a little bit of the entertainment industry itself, isn't it? You have to be a little bit of a showman, don't you?
Absolutely. And I tell people this, and frankly, it's not specific to disputes within the entertainment industry, especially now with all the TV coverage and movie coverage about trials. When we get our trial team ready to turn the corner, so to speak, a few months away from a trial, I say, look, we're putting on a show. And you have to think of yourselves, you're here to educate and entertain the judge and the jury. You're a writer, an actor, a director, a cinematographer, all of those things, because they are expecting a performance. And if we don't deliver, we're going to lose. So you have to recognize that that's part of the job.
There can't be anything worse than a boring lawyer.
There can be a boring lawyer who's also dishonest.
Oh,
yeah, you're right. You're right. Boring is about the worst. Yeah, bad idea.
So not to be too cynical about it, but a dishonest lawyer, do they exist?
Shocking, isn't it? Just like gambling going on at Rick's Cafe. I mean,
okay, so what is it that you think makes you unique, that makes you so good at what you do? What is it?
I don't want to be that presumptuous, but
Go ahead, be presumptuous.
I think that it's a combination of caring about the clients, being interested in the analytical side, the intellectual challenge of the problem, and wanting to come up with a solution that nobody else had thought of that results in a successful outcome, coupled with a willingness to work really hard and bring my forensic skills to the table or to the lectern at the right moment. And I'm also a pretty good writer, I'm told. So it's a combination of a lot of things where, plus having done it for a while, I hope I'm a pretty quick study, and don't need a lot of facts before I can say, okay, fine, I get it. I see where this is going to end up. Here's what we need to do.
So some people probably don't think of most lawyers as being creative types, but I'm willing to bet that you're a fairly creative lawyer when it comes to looking at a case and trying to figure out the best way to present it. Would I be correct in assuming that?
It's a little uncomfortable to talk about myself this way, but I think if you're not a creative lawyer, you really don't have much to offer. You're not a value add proposition, and especially at the hourly rates that top firm lawyers charge, you really can't justify your existence. If you're doing the same thing that everybody else would do under the same circumstances, why hire you? So I'm always trying to think of something that's a little different and maybe a little more clever and hopefully a little more laser-like to cut to the chase and solve the problem, get the client out of legal danger, or nail the other side to do what they should do.
I have had a lot of experience with attorneys myself. And one of the things that I noticed is the better attorneys are creative. They're not just cut and dried meat and potatoes. There's an actual process to it that has a creative bent. That's what you're talking about, correct?
It is. Ultimately, whether you're talking to a judge or a jury, you have to have a compelling story. You have to have characters and this starts sounding a little familiar to what you do. It is for different reasons, but you have to get the people who are going to decide your client's fate to like you, to think that you've got a compelling story, and that without even caring about what the law is or isn't in certain things, just hearing you tell them in 15 seconds what the case is about, they're ready to rule in your favor. And that does take some creativity, because you could take the same set of facts and tell someone what you think it's about 5, 10 or more different ways. And some of them will be really pointless and boring and tedious. And some will be, wow, you got to be kidding me. That's horrible. Or this claim is just ridiculous. It's frivolous. Of course I'm going to rule in your favor. So yeah, there's certain creativity in that. And it permeates everything you do in terms of how you write the briefs you write, the discussion of the facts, the way you cross-examine witnesses, the way you present your own witnesses, the things you throw up on screens in front of jurors, everything, soup to nuts. You've got to be a good storyteller. And that takes some creativity for sure.
It's sometimes, I think, forgotten that you are dealing with humans at all times. The judge is human, the jury's human, the clients are all human, and we have our own human faults and foibles, no matter who we are.
Absolutely. Yeah, I think maybe I majored in economics, and I think that's helpful, but psychology might have been a better course of study for preparing for this.
So, all right, now let's talk a little bit about what it is specifically you do. Most of your casework that I looked at is in some way, shape, or form around intellectual property, or at least a significant part of it is. Can you explain for the average listener what intellectual property means? I don't think it's as obvious from the words intellectual property, but what does intellectual property mean?
Right. Well, property, most of us would think, oh, that's somebody's house or the dirt on which the house sits, or it's your car. These are physical things. Intellectual property are things of the mind that have value, that either are written down in some form, like a song lyric or a book or a computer program, or maybe they're not written down, they're ideas or trade secrets, and they have value. And there's whole systems of law designed around how to protect those, whether we're talking about a patent or a copyright or trademark or a trade secret. So there's all these bodies of law with their own little rules and procedures for protecting these products of the mind. And as our economy and our society has matured, it is the products of the mind that have become most valuable to the way we've organized our society. We're an information society, and that's information is usually begins as a product of the mind. Television programming is obviously the result of products of the mind. Music has, for example, there are 2 different copyrights in every sound recording you hear. There is the copyright to the underlying composition by the songwriter. There is also a copyright in the performance that's been recorded in a tangible medium. So when we talk about intellectual property, we're talking about all kinds of things. But as they pertain to the entertainment industry, we really think of them almost synonymously with content.
When you say content, you're talking about programs, product, you're talking about TV shows, movies, books, et cetera,
Video
right?
games, everything like that. Newspapers, magazines, all of the stuff you can read, see, or hear are forms of content.
And how much over time has that become more and more prominent in the world? Hugely, yes?
Absolutely. Absolutely. I mean,
especially with the internet.
Yes, and there's all kinds of additional intellectual property on the internet. Domain names, for example, that's a form of intellectual property that deserves some protection. But yes, we manufacture less, or in terms of physical goods, cars and steel and raw lumber, and more we create things out of our mental energies that take the form of what we call content or intellectual property. More and more and more. It's a significant part of the modern world.
How important is it, do you think, for a writer, if they finished a book, a screenplay, a poem, whatever they're writing, how important is it for them to immediately copyright it with the Library of Congress in Washington, D.C.?
Well, the legal right and the entire copyright regime immediately protects that work without registering it at all. Mm-hmm. Once you write something down in what the term of art is a tangible medium of expression. So it's inside a Word file, it's on a manuscript of pieces of paper, whatever it is, you dictate it into a tape. At that moment, you're protected by the copyright laws. So if somebody makes use of it somehow without your permission, you have rights. You can't sue them without registering the work for copyright, and you can't get statutory remedies and attorney's fees for acts of infringement that occur before you register it for copyright. Mm-hmm. But you are protected. So how important is it? Well, it's an expensive proposition for somebody who is simply writing on spec or for their own, whatever. I think it's a few $100s. I can't remember what the latest fee schedule is. And if you need to expedite it, that's called special processing or special handling. That's even more money. If you need to protect your rights, let's say you wrote a book, you didn't register it for copyright, and you published it, and then you felt somebody ripped you off, you absolutely have to register it for copyright before you can take legal action.
So in other words, it's copyrighted once you have put ink to paper, or I guess even digitally online or on a computer.
Yes.
It's automatically copyrighted, but then to then validate it, I guess.
Can I interrupt? It's
sure.
Not. I mean, if we say copyrighted, people might misunderstand. It's already subject to the protections of the copyright statute.
Good.
So it can't be, you as the author or the owner of the copyright at that moment have the exclusive control over making copies, distributing the work, preparing a derivative work like a sequel or adapting it into a stage play or a stage musical. Those are rights you control instantly. And so it's not copyrighted. I think most people associate the term copyrighted with, now you've also gone the additional step of registering it with the Copyright Office, and you have a certificate of registration. That does require that additional step.
That's a step toward making it more legally binding, yes?
Well, it's a step towards giving you the right to sue. It's a step towards, if you sue, claiming certain remedies like attorney's fees or statutory damages, which may not be that significant if it's a really bad ripping off, if you will. And it's a way of putting the world on notice, or constructive notice, that the work exists, because people regularly search the records of the Copyright Office for certain works to see if they are in fact registered. So it's kind of like, like in the old days of the Old West in mining, it's kind of like staking your claim.
All right. So what is the most common type of copyright infringement case that you see? Is it that someone has literally ripped someone off and they've word for word reproduced it in some way? Or is it that they've taken that concept or idea and used it in a fundamentally or substantially similar way? What's more the most common thing that you see?
Those two are probably the most. There's also this other body of cases where people suddenly come out of the woodwork and say, hey, wait a minute, you've been exploiting this, and you thought You radio station, you streaming service thought you never needed my permission, but you did. And you not only needed permission from me, you needed it from the thousands of other performing recording artists whose recordings you get a lot of that. There's a lot of those cases. In fact, we were just talking to people about one yesterday. But the first set of examples that you gave me are very common. Somebody will say, hey, wait a minute. I just saw this Disney movie Inside Out, and it sounds a lot alike a story I pitched to Disney that I wrote down and submitted a 40-page outline to so-and-so in the feature film division of, whatever within the Disney company. And you violated my copyright and I'm suing you. That's very common.
That's really common. What do people get away with copyright infringement on a regular basis?
It's a really good question because they're hard. Copyright infringement claims are hard to prove where you're dealing with trying to compare two works.
How does that work for you? Do you take those two works and sit them side by side and actually go
you
word,
do. There's
word
actually, I'll give you an example. A couple of years ago, I represented MGM and Danjak, and they collectively own and control the rights to James Bond. Another studio in town had announced a project that I remember the name, but I won't say the name. And it was announced that they were putting it into development and rushing it into production. And I can't remember if we got a hold of the script or somebody knew about it, whatever. Anyway, we sent a letter to the studio and said, you're ripping off James Bond. And they said, actually, they wouldn't, I don't know what happened. Anyway, we filed a lawsuit for copyright infringement and they moved to dismiss the case. And so in order to evaluate the sufficiency of our claim, there's a recipe or a method that the courts are supposed to use. And this varies around the country, but there's a test that a judge applies and the judge looks side by side of the two works and looks at the similarities with the plot, the theme, the characters, the dialogue. There are several other factors. This is called an extrinsic test. And you filter out similarities that you would expect to find in that genre. You filter out similarities that are really at the level of an abstraction or an idea, because copyright protects expression of ideas. It doesn't protect abstract ideas. And you see what you have left. And the judge makes an assessment and says, okay, this is good enough. This is not good enough. And that's a well-known test that gets applied in all of these cases. That certainly they get litigated in the federal courts in California. Most of these cases lose at that initial stage of the case. And there's been some criticism that says the courts have raised the bar on this test of this is all to determine if the works are substantially similar.
Right.
And there's been some criticism that says some judges have been too eager to dismiss copyright claims at the very start of the case and impose too high a bar. And so these cases right now, if you were to say a snapshot of 2022, it's probably the pendulum has swung more in favor of I'll call it the defendant, the studio, the party that's accused of infringing the writer's work.
You when you're talking about Danjak and MGM and so on, you're talking about companies that are big with substantial resources. You're talking about a series of movies that have been around for 50 years plus. And so there's a real substantial amount of money involved in the potential loss of that. Is there a point in a much lesser case where it's just a standard writer that is not a big company? Is there a point at which bringing a suit makes sense? And does it require the considerable loss of money, or is it worth it to sue for much less than that? When do you make that determination?
Yeah, well, let's put aside, there's kind of a new twist in the law in copyright in the last couple of years for certain disputes of certain dollar amounts. It's kind of like a small claims court for copyright that's almost getting, or maybe it has finally gotten underway. But let's say you have a writer. And by the way, when I mentioned the Disney film Inside Out, I mentioned that because a writer claimed that that movie was based on his or her treatment.
Huh.
And These are the David versus Goliath situations. They do arise quite often, and they've arisen over. I mean, you can go down the list. I could think of quite a few movies where, generally speaking, the more successful the movie is, the more critically acclaimed the movie is, the more likely it is that someone is going to claim they were ripped off. Here's a
Sure.
slight variation on this. I don't know if I'm dating myself when I say this, but I'm a progressive rock fan, a prog rock fan, and one of my favorite bands is Yes, and their early albums, the artwork was done by an artist named Roger Dean, and these were these ethereal, otherworldly, science fantasy kind of images and really interesting album work. And when the movie Avatar came along, I was sitting in the theater thinking, wow, this looks a lot like Roger Dean's work. And sure enough, he sued Fox and Jim Cameron for the look of these sort of floating massive rocks with trees and moss growing
Sure.
on them. And, it would be very hard to think that somebody created that without having been inspired by Roger Dean's copyrighted illustrations. He lost. Case did not go very far. So he had to make a decision. Is it worth suing over this? He thought it was. It's not cheap. And if you are an established player in the industry, you have to ask yourself, am I going to make myself a pariah if I sue the big studios or one of them and get a reputation for being a troublemaker? So a lot of these things just kind of cynically get overlooked, frankly.
So I guess to follow up on my thought, it really requires there to be some kind of real loss or potential loss for even the thought of a suit to come in. So for instance, two people are sitting together, they're having lunch, and they start talking over different ideas that they have. And one of them goes off and writes a script and incorporates a few of those ideas. Neither of them sell any of their work. Nobody's suing anybody, correct?
Correct. But a couple of years ago, I'll give you another example. I came in right before trial, very well-watched television series on Netflix called Stranger Things. And during the first season, the Duffer Brothers were sued for, this was not a copyright claim. This was sometimes called an implied in fact or law of ideas claim. But this person said, hey, I met the Duffer Brothers at the Tribeca Film Festival, and they were on their way out to Montauk, Long Island, doing research for something, or can't remember if he said they told him that. But I told him this project I was working on and a book I'd written and a short film I'd made, and they used that as their inspiration for Stranger Things, and they owe me big time. I remember about a week after we came into the case, right before trial, it was like 2-3 weeks before trial, I deposed their expert on the issue of similarity between the plaintiff's creations and what the Duffer Brothers had done. And the case eventually settled, and it never went to trial. And I think I may not be allowed to talk much about it, but
well, don't then, please.
It was very helpful that the Duffer Brothers were working with Google Docs in their work, and they had date and time stamped versions of stories that became Stranger Things years before they ever met this fellow at the party. So it was very obvious, no, you didn't, frankly, they didn't even remember ever meeting the guy. But there was pretty objective evidence that this was entirely their creation. And the case did resolve, and part of the settlement included a statement from the plaintiff recognizing that he had misjudged the situation. And in fact, the Duffer Brothers were the legitimate creators of the show.
What you're talking about, and correct me again if I'm wrong, but it does happen frequently there where people think that somebody else has ripped them off, when in fact they really weren't ripped off at all. There's just similar ideas in the ether at the same time.
Yeah, constantly. And there are plenty of cases involving this. Steve Bochco was sued over one of his TV series involving a hospital. And yeah, it's very easy. And you see this in the cases, like, if you have a show about cops, you're likely to have scenes where maybe one of the cops is Irish, and if they're in New York especially, or, they're hard drinking, or they have marital problems. That kind of stuff just it's background noise. That really doesn't
It's
mean
common. It's common stuff.
exactly. The term in copyright is scène faire, which is French, and I apologize for using a big word like that, but it's to be expected within the type of work you're using, and it's not protectable.
So looking at this a little differently, and I've experienced this, and I'm curious about if you have advice for artists on this. It is sometimes really difficult for an artist, a writer, a director, producer, whoever, who would like to obtain the license or the right to use a copyrighted work. And so it's under copyright. You can't just, you want to get a book and you want to adapt it into a screenplay. Do you have any advice for artists that are trying to obtain copyright for the best way to go about it? You almost always have to have an attorney represent you. Am I correct?
There's no legal requirement to have an attorney, and plenty of people do deals for options and purchases of literary rights without attorneys. It's probably a good idea to have an attorney. In fact, if you're paying money to acquire rights, or if you're getting money for your rights, at that point when you're making a deal, I would definitely get a lawyer and somebody who knows these things and understands what to put in the agreement. But I'm jumping ahead. You're at the point just where somebody says, hey, there's this book out there that I would really like to write a spec screenplay on, or I'd really like to produce in a film. What do I do? How do I do it? And, that's not my end of the business. Normally. That's people who I used to work with end of the business. But it's usually not very hard to figure out if either you have an agent or who represents the writer. Contact the publisher of the book, and the book publisher will tell you who represents the writer, and or if the writer represents herself or himself, and you go from there.
So I'm going to get off of that because it's not your field of expertise, but nevertheless, I will tell you from my own experience and those of many writers who are out there, it's usually really difficult to even get to the right person at a publishing company unless you have someone representing you going in.
I understand.
It's
yes,
very
I
difficult.
agree with you.
So, all right, let's talk about different disciplines now. Is there, of all the different disciplines that you sort of go through between unfair competition and royalties and participation and defamation and copyright and trademark, is there one that you prefer to work on over another? Is there one that your favorite?
Not really. I love it all. What I really like about what I do is that every case is different, every client's different, and it's a new intellectual challenge. And if we're the same thing over and over again, I probably would get bored. What I like is
you'd be back to being a contracts lawyer again.
Yeah, It's like, all right, what am I doing here? I gotta find something better to do. So
what is a trademark then? Because I think many people think that copyright and trademark are the same thing.
Well, they're similar, but they're not. A trademark is usually, how do I do this without sounding like a jerk from law school? So the idea.
I'm sorry, I've asked you a jerk from law school question.
No, that's fine. I just don't want to be like, Bobby, what kind of answer is that? So think of a trademark as an indicator of the source of something, of a product, a good, a service that signifies. I'm being too esoteric. A trademark would be like the brand of a product. A trademark would be a logo, a design, the Ford oval with the word Ford in it as a logo. That's something that you can trademark. It might be a slogan of a company, or it might be the name of their product. Advil is the trademark for a brand of Motrin.
Kleenex, Coca-Cola.
Well, Kleenex is really interesting because Kleenex was that for a while is and still is at the risk of what we call being genericized, because
everybody says Kleenex.
They say Kleenex, and Kleenex doesn't like it when we say Kleenex. They want you to say, no, it's a facial tissue. Kleenex is our brand. And if you keep calling everything a Kleenex, you're ruining our brand. So don't call it Kleenex. Call it a Kleenex brand facial tissue. And
is Mickey Mouse trademarked?
Yes.
So Mickey Mouse is iconic in that way and part of the brand of the Disney company.
It's certainly one of the Disney company's brands. And here's something that's interesting. Eventually, who knows when, should be soon, the copyright to the very early Mickey Mouse or Mortimer Mouse content is going to lapse, and some of it is going to lapse and fall into what we call the public domain, which means that you might be able to make a cartoon right? Cartoon character that looks exactly like Mickey Mouse. But trademarks don't have end dates associated with them. They live in perpetuity as long as you continue to use the mark in commerce, which of course the Disney company is doing. So while if we assume for discussion that Disney might not be able to protect Mickey Mouse under the copyright laws, it sure as heck is going to continue to be able to protect the name Mickey Mouse under the trademark laws. So if you call your slavish copy mouse Mickey Mouse, you're in trouble. If you call it instead, Muddy Mouse, or something that's not likely to cause confusion with the name Mickey Mouse, you might be okay. But don't dare call it Mickey Mouse, or you're going to get a letter from the Walt Disney Company's legal department.
Is it true that, so I've heard over the years that it is the Disney company that has pushed copyright law further down the road than anyone else?
I don't know for anyone else, but it is true. I was involved in some litigation in front of the Supreme Court 1998-ish. It was the Sonny Bono, whether the Sonny Bono Copyright Extension Act of 1998 was constitutional, whether Congress had the authority to extend the term of copyright. And the Disney company and many companies that had extensive copyright portfolios were supporting the law. Disney was certainly one of them, but they weren't the only one.
So you brought up the Supreme Court. I'm fascinated that you have been in front of the Supreme Court. How many cases have you tried there?
Well, I'll be honest, I have not argued in the Supreme Court. I've had 5 or 6 cases go to the Supreme Court. My colleagues who have far more experience and are better known, to the members of the court have argued these cases, and they're exceptionally good specialists for that. But I had a case. It was definitely at that point a highlight to have won that case the way we did. But I had a case in 2004 or 5 in front of the Supreme Court dealing with copyright and the pirate websites like Napster and Grokster and like that. And I got the Supreme Court unanimously to adopt my theory of copyright infringement that turned the case completely around.
Wow.
Representing all the studios, the record companies, and the major broadcasters against a peer-to-peer service that was it was the follow-on to Napster. It was called Grokster and Kazaa, and it was much smarter from a technology standpoint and an evasion of copyright law standpoint. We lost in the district court, we lost in the appeals court at the Ninth Circuit, but we got the Supreme Court to turn it around unanimously, and it was based on a legal theory that I had thought of. And everybody was saying, that's nonsense, Bobby. That's sophistry. And I said, no, I'm telling you, this is not only is this the right answer, but I know the Supreme Court will like this.
Is when you're preparing that, you helped to prepare the case, but you didn't try it,
yes.
Right?
Yes, you don't try cases at the Supreme Court. You just argue them for a half hour or an hour, whatever they give you. You brief them, and you just answer their questions at oral argument. And then a few months later, they issue an opinion. And I was heavily involved in all of that.
Would you say that the amount of time and energy to prepare for the Supreme Court is different than a standard court case, or it's just another court case?
It's just another case. I mean, it's just another appeal. Obviously, if it's a Supreme Court, you're going to, and the client is willing to go along, you're going to put a lot of time and effort in it. But it's over a short burst of time. So cases that go to trial last longer, and you probably put more time into those.
Okay, so what is unfair competition? I mean, it's obvious on the face of it, unfair. It's not fair competition. So what is it? Well, how does that work?
Yeah, there's a little slang in that. There's a couple of flavors of it. There's the trademark law version of unfair competition, which is if you have an unregistered mark, and which I'll circle back to in a second, and you want to sue somebody for competing against you with a product, a good or a service, a logo, something that is likely to cause confusion. That is a form of unfair competition. There's also, at least in California, and other states have these unfair competition laws where if a business engages in practices that are unfair, unlawful, or fraudulent, there are statutes that call that unfair competition. It has nothing to do with the brand of your product. It might just be false advertising or doing anything that basically doesn't smell right.
Is there unfair competition? We're in a political time right now. Is there unfair competition in politics? Does that exist?
Well, not legally, no, because the speech within that would form the basis of those claims is entitled to full First Amendment protection. So if like a politician lies, the courts aren't getting into that. That's for the voters and the politicians or the candidates to hash out on their own. The judicial branch doesn't really get involved in policing it. The Federal Elections Commission might, but that's not it's not really supposed to be something for courts to deal with, unless a politician would defame somebody. That's a different question.
So I want to go into just a little bit about my two favorite words in the English language: royalty streams.
Okay.
I have the good fortune, my listeners know that I have, over time I created a show called Jekyll and Hyde. And one of the things that show has done is thrown off a lot of royalties. So what is royalty and what is then participation, and how are they related? Is it the same
They're
thing?
very similar. Yeah. Participations is kind of a term of art within the filmed entertainment side. Royalties tend to be thought of in recorded music or computer programming or patents, but it's all the same sort of thing. The idea is you're getting paid on the success of the exploitation of what you created. And exploitation in this context is not a pejorative. It means,
To use.
Right. Yeah. It's a term that you'll see in contracts, revenue generated from the exploitation or receipts generated from the exploitation of the property, the project, the play, the musical, the movie, the series, whatever. That's the way the contracts describe them. And so the idea being that you get some money up front, your fixed compensation or your episodic compensation, if we're talking about a TV series, and then you're rewarded on the basis of the performance of the release of the product or remakes and sequels or novel, whatever other exploitation, either on the basis of a box office bonus, which has become more and more common, very easy to calculate, or more complicated formulae where it's like, okay, we're going to give you MAGR, modified adjusted gross receipts. So, pages and pages of definitions that essentially describe a formula that hopefully leads to you getting a lot of money.
We will not get into NAGBOR, which is net adjusted gross box office receipts, because that just gets crazy.
Or FUBAR. No, that's not true.
Oh, we could get into FUBAR all
right.
night long. Okay, so what then is a residual? Is it the same as a royalty?
Residual is another term of art that we tend to think of as something that relates to the guilds, and that this is something that the
guilds being the Writers Guild, the Directors Guild, the Producers Guild.
Or there's not producers don't get residuals. Screen Actors Guild, Writers Guild, Directors Guild.
Got it.
Or SAG, IATSE. But yes, and this, if you want a little bit of history, when Ronald Reagan was president of the Screen Actors Guild in 1960, they went out on strike and they were pissed off because the studios were then in the late 50s showing movies or licensing their theatrical movies to the television networks as a way of generating extra money. And nobody besides the studio was getting any share of that. And everybody thought, well, that's kind of crappy. Let's go out on strike. And the upshot of the strike was to create this concept of residuals, which then morphed from SAG to the WGA and the DGA. And so the idea being that the distributor of TV content in any form, home video, over the air, cable, streaming, whatever, they have to create a relationship with the three guilds for residuals and account to them periodically for the revenues they generate. And there's a formula that says, X percent. I think if you think of it in the aggregate, it used to be, it could be wrong, maybe somewhere between 14% of the revenue that's coming into the studios from television exploitation ends up going to the three guilds, and they come in periodically together and they audit and they sue if they're not happy, and that's what residuals is.
Are most disputes because somebody's holding back a payment? Is that what most disputes are about?
Oh gosh, there are all kinds of crazy disputes. Maybe the dispute is the studio packaged 15 movies to France and they got $1 million, maybe they got $15 million, and they just gave each of those movies $1 million in gross receipts. regardless of how well-known, awarded, or financially successful those films were. And
So you put a really famous movie together with 14 movies nobody's ever heard of,
exactly.
and that
You
one
make a
movie's
package,
carrying the
and,
load.
and that's called the engine, and that drives the package, and you screw the participants on the successful film by allocating away some of the money to the loser films, where especially if you have agreements for participations with the talent on those movies, they're never going to see anything anyway. Those movies never broke even, so it's just a way of diverting money. That's one thing. The streaming world has created all kinds of opportunities for mischief by the studios that we're still sorting out and litigating or not litigating. I mean, it's
Is that the recent Scarlett Johansson
I was
beat?
about to say that's a version of it, not in residuals, but in her compensation, because she had a deal with Disney that paid her on the basis of how that film performed, including in theaters. And then they decided, we'll just send it to Disney Plus. And then she says, well, what am I, chopped liver? I mean, how are you going to make this up to me? Warner Brothers, Jason Kilar, who's no longer there, really screwed the pooch with that when he made his announcement in, December of 2020, that all the 2021 releases were going to go day and date on HBO Max, and pissed off a lot of people, generated a lot of conversations between lawyers and the Warner lawyer legal department over how they were going to do right by the people that were affected by that. So yeah, and there's other submarines out there that you may be hearing about soon enough.
For the listeners that don't know the term day and date, it means that it used to be that, or still is really, you release a movie in the theaters, they get their run in the theater, and then somewhere down the road, a month, 2, 3, 6 months, whatever down the road, then it gets released into cable and into streaming and so on. But now the studios are releasing them into the theaters and streaming or onto cable on the same day. That's day and date.
Yeah. And what's nefarious about it, in the abstract, it's like, well, who cares? What's nefarious about it is, well, usually the streaming service that movie goes to at the same time that it's in theaters is it's affiliated with the same studio. So the Disney movie shows up on Disney Plus, the Warner movie shows up on HBO Max, the Paramount film shows up on Paramount Plus. And so they're doing really well. But it doesn't show up on Netflix, it doesn't show up on Amazon or Apple Plus. It never was sort of sent out into the marketplace to see who would pay the most license fee for that. And so the claim is that the studio is underpaying for the right to show it on the affiliated streaming service. Does a lot of good to the streaming service and the parent corporation, but it undercompensates you and the other people who worked on the movie.
Okay, so let's briefly talk about defamation, which I know you get into somewhat. We've just in the public eye recently, we're recording this show in June of 2022, and we've just gone through a huge trial that involved Johnny Depp and Amber Heard, and it was a defamation suit. And so what is defamation, and why is it so hard to prevail in?
So you're telling me there was a recent defamation case involving, who was it again? Johnny
Depp and Amber Heard.
Hadn't heard about it. So the defamation is, and I've told friends of mine who want to call me and say, Bobby, you know something about it. It's like, we're not talking about that case anymore. It's over. Let's find something else to talk about. So defamation is, the idea behind defamation is to protect your reputation, and somebody defames you in the sort of high level sense of it. If they say something about you that's false, that's about you, that, in other words, and that was an issue in the Depp trial because her editorial didn't mention Johnny Depp by name, but they make a statement about you that's false, that tends to harm you in your business or reputation, or accuses you of unsavory or criminal behavior, and causes you damage. And the reason defamation claims there are many reasons why they are so hard to win. I'm pursuing one now against the New York Post in Montana, and especially against media companies, and especially if the person who has been defamed is not an unknown person. If you're the subject of the defamation, the plaintiff, the injured party, is a well-known person or known person, then in order to prevail, you have to not only do all of the things I just mentioned before, a false statement, the that harms them, etc., you have to prove something called constitutional malice, which means that when you said what you said, you either knew you were saying something false or you were being reckless. You had a reckless disregard for the truth. Sometimes that's characterized or restated as you had serious doubts that what you were saying was true. And that's called malice or constitutional malice. And that applies to public figures like politicians and the like. If you say something bad about Donald Trump and he tries to sue you for defamation, there's a pretty high bar for him. It applies to well-known people, and it applies also to something called limited purpose public figures, which means there are some people who are well-known on a particular issue, and if they sue you for defamation, they have to prove you had this constitutional malice.
So is it possible to defame a not famous person?
Oh, it is, and the standard is much lower. So if one person who lives across the street from me tells me that the person who lives on the other, their next door neighbor is a child molester, absolutely, that's defamation. And I don't have to, and if they sue the person who's told that about me, they don't have to prove that they knew it was false or that they entertained doubts about it. If it's false, they lose. It's a much lower bar.
It's a much lower bar. All right. So tell me what your biggest hurdles are typically going into a court trial where you're actually at trial. What are the biggest hurdles you typically deal with? Is it figuring out the jury? What's
You're talking about defamation or any case?
Oh, any case.
Oh, okay, fine. Yeah. So I think the biggest thing you think about is, do I have a compelling story to tell the jury? Do I have a compelling case? Forget about the law. Just like, in terms of what this person did to that person or this company did to that person, whatever it is, do I have something that I can explain to the jury in very simple and emotional and compelling terms? Or is this a case where to really tell what happened, you've got to dive into a ton of details and you're going to risk losing their attention, and they're going to think because you have to go into so much detail, you must be hiding something and you're really a liar or whatever. What is the core, simple case theme? And is it compelling? And frankly, of course, is it true? In other words, do the facts support it? If you try and sell the jury on something that's not true and your adversary is awake, you're going to get killed. Mm-hmm. So it's got to be true. And everything works kind of backwards from that. But you've got to really think about that. And then you think of everything else. What are you going to say and all that?
Early on, we talked about that you're telling a story, that there's a narrative to what you're going to do in court, and how similar, it's amazing to me how similar it is in what you just said about when you go to pitch a movie or a TV show or some story to someone. The simple stories always are easier to sell.
It's the same thing. I mean, look, we're human beings. The psychology, my dad always says, or used to say, that you can't change human nature. The way we've evolved, the way we are wired, this is the way we absorb information. This is how we make decisions. This is how we think about things. And for you pitching an idea to a studio or somebody on Broadway or whatever, it's the same thing. I'm trying to get them to buy.
In a court, in a court of law, it's the same thing.
Absolutely the same thing. And judges, frankly, they're, for all whatever their education experiences, they're human beings, and they're the same as jurors. Maybe you can be a little more, weaving in the law in terms of art that the jurors wouldn't know, but it's the same thing. You got to keep it simple, honest, and if and it's got to ring. It's got to be compelling. Somebody's got to say, you know what, I'm going to get off my ass. I'm going to listen to what you have to say for the next few days. And I'm going to give you my vote when we go deliberate.
Mm-hmm. I have to imagine that a lot of what you do is pressure packed, that there's pressure in it. What do you do to handle pressure?
Well, I have a hammer and I'm allowed to destroy the walls. and once a month I come in and patch them up. No, I try and get exercise. I try and not stress eat. And I have a phenomenal wife and son and two amazing dogs. And we are a team. They're very understanding. My wife is also a litigator and
she really understands.
She really understands. Her sister's a deal lawyer in New York, a very successful, accomplished one in the hedge fund space. I love to ski and get some exercise.
So
Crossword
you like to
puzzles.
blow off steam physically.
That, and I like reading and doing crossword puzzles and painting.
Hmm.
But
What kind of paintings do you do?
well, the medium I use, I mostly are acrylic because that's what I learned with. But in terms of the subject matter, it's all over the place, from portraiture to landscapes to abstracts. Who knows? But the problem is I rarely have time, and so it's
Mhm.
like, it's a perishable skill or whatever. So the first time after, it's been a couple of years, frankly 2 years probably since I did anything. I'm sure if I go down to my little work area off the garage, it's going to be like, wait, what am I doing here? How does this work again?
Oh, you'd pick it. It's like riding a bike. You'd figure it out right away. So, all right, what makes a good client good? What do you want in a client that's helpful for you?
I want that client to be totally brutally honest with me. And then I want them to realize that if we're going to be a team, and if we're going to form a team, they have to understand that this is going to be an endurance test. It's going to be distracting. It's going to be stupidly expensive. And I can do my job for them only if I know the good facts, the ugly facts, and when I need their attention, to have their attention.
And so that's true for both an individual client and a corporate client.
Absolutely.
So there's no difference between that attitude.
Not really. They're both, if they're usually pretty savvy people within companies. They understand the PR ramifications of what we do. They understand the economic, financial consequences and risks and the expense of litigation. Yeah, it's very similar.
So I have been speaking to Bobby Schwartz, who this has just been an absolutely fantastic conversation about the law and lawyering and what's it's all about in the entertainment industry mainly. And we're going to wind this thing down a little bit. And I'm just wondering, in all of your experiences, in all the things you've been through, can you share with us a story that's either weird, quirky, strange, funny, or just weird?
Well, I've been blessed really with having a lot of fun and a great career, great clients, and great cases. So it's hard to kind of come up with one thing, but there is one thing that has stood out in my mind over the years of just bizarre. I was representing a company that made movies, obviously, and one of the movies was a baseball movie with Charlie Sheen called Major League. And there came a point where I think he was in Japan promoting the film and refusing to leave his hotel unless the studio gave him a large envelope of cash for whatever purposes he chose to use it with. And if they didn't give him the money, he wasn't going to go out and do interviews and promote the film in Japan. And that was an important market for a movie about baseball. So I wrote his lawyer a letter, and I can sometimes be a little snarky, and I thought that was just appropriate here, saying, for a guy who everybody thinks spends his time with hookers, to be demanding a big amount of cash is not going to play well if this gets out. And I promise you, if he doesn't get out of that hotel room and onto the junkets, it will. So tell your client to go do what he's contractually obligated to do, or otherwise we're going to sue him and it'll be public and da 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 da. And so he did. And then a couple of weeks later, I'm sitting in my office and the phone rings and some guy says, "Hey, is this Bobby Schwartz?" I said, "Yes, this is." He goes, "This is Charlie Sheen." Now I can't imitate his voice, and you could tell he was driving in a convertible, or whoever this person was. And it did sound like Charlie Sheen. And he said, "What's your effing problem? Why are you being such an a-hole to me?" And went on this total tirade. And he said, "Loosen your effing tie. I'm coming to your office right now and I'm going to beat the crap out of you." And And so I started laughing because I figured it was Charlie. She sounded like Charlie Sheen, but I thought it was so like stupid and pathetic. And the more I laughed, the angrier he got. And I said, "Come on over. Yes, I'm happy to see you." And it just showed me how bizarre. I can't repeat with the same enthusiasm that Charlie Sheen can bring to a role.
That kind of insanity is not exclusive to celebrities, but it sure is prevalent in the celebrity world. We see too many instances of famous people just popping off in weird ways.
Oh my God, the stories I could tell you about some of my clients, but I have to protect their privacy. But some of the people, and these are household names who I've been honored to represent, have said things to me like, it's just like, what? But I mean, they live in a different world.
You know, if you ever get out of the business, you could maybe write a book.
I'm not going to do that. No.
No, I wouldn't expect you to. All right, last question for you today, Bobby. Do you have a solid piece of advice or a tip for someone who is perhaps interested in doing what it is you do, or maybe they're in a little bit and they're trying to figure out how to rise up to where you're good at?
I'll admit it's not easy. There are lots of people that like to do this work, so you will be competing against other people. But you can give yourself some advantages, and it's going to sound I don't know, try it or whatever. But no success comes without a tremendous amount of work and hard work, long hours, and sacrifice. So you've got to be prepared to do that. You've got to get yourself well informed and well educated. So if you're interested in the entertainment industry, you need to be reading the trades every day. They come to you electronically now. You need to read Company Town and the LA Times when they're doing that. You've got to stay well informed, and you should join professional organizations within the industry to meet people, because again, this is a long-term investment, but when it starts paying out, it's like an annuity, because these people stick around and you have this, but you've got to meet people. So if you're a lawyer, join a bar organization that focuses on the entertainment industry and go to its meetings and, pursue it. And if it's not a lawyer, if it's some other thing, then do this, whatever it is, you've got to get in that, you get nowhere by staying inside. You stay inside, nobody knows who you are. So get out there, get in the mix, and meet people and be yourself, and recognize it's going to take time.
That is just fantastic advice. And by the way, applies to people in the entertainment industry as well. It's not just lawyers that need to do exactly what you're talking about. Everybody in the business needs to do what you're talking about, but in particular, you need to circulate and get yourself well known.
Right.
So Bobby Schwartz, this has been just a terrific hour on StoryBeat, and I can't thank you enough for taking the time to. Thank goodness I'm not having to pay for your hourly rate. That's all I'm going to say.
Yes, yes. Thank you. I enjoyed this very much, and I hope it was good for you too.
This was terrific, so informative and very entertaining. Thank you so much for being on StoryBeat.
Thank you, Steve.
And so we've come to the end of today's StoryBeat. If you like this episode, won't you please take a moment to give us a comment, rating, or review on whatever app or platform you're listening to. Your support helps us bring more great StoryBeat episodes to you. StoryBeat is available on all major podcast apps and platforms, including Apple Podcasts, YouTube, Spotify, iHeartRadio, Stitcher, TuneIn, and many others. Until next time, I'm Steve Cuden. And may all your stories be unforgettable.